Assalamualaikum warahmatullahi wabarakatuh. The concept of coordination reform between Polri institution and the public prosecutor office in pre-prosecution. Coordination between the Attorney General's office and the police in the pre-prosecution process is experiencing problem. Currently, the Criminal Procedure Code and other related laws and regulations only regulate the period of times for the public prosecutor to study, examine, and arrange for investigator to complete the examination program file. The purpose of this study is to produce a concept so that coordination between the prosecutor office and the police can run well, so that the pre-prosecution process does not hinder the law enforcement process, because currently the pre-prosecution can take a long time due to the back and forth cases. Coordination between the public prosecutor institution and investigator since the start of an investigation stage or case title, so that the different approaches between investigator and prosecutor have been elaborated since the beginning of the investigation. Or it can be said that relation between investigator and public prosecutor is a communication space, not like post-hoc between investigator and public prosecutor. If this happens, back and forth examination of case file become unnecessary or very minimal, because investigator and public prosecutor already have aligned views and need for proof. So that in carrying out an investigation, the two can complement each other. There is no need to wait until the end of investigation process, which is only limited in time to 14 days. Conceptually, ideal relation between public prosecutor and investigator can be carried out if the inter-subsystem are not limited by subsystem partition, functional differentiation. There need to be a regulation in the Criminal Procedure Code regarding the limit for returning case file from prosecutor office to the police 3 to 4 times the return of case file after exceeding the limit. The prosecutor must take a stand regarding the case. The National Police of the Republic of Indonesia, hereafter abbreviated as Polri, has duties and function as law enforcer and services to the community. The borne by the Polri result in a lack of maximum performance in carrying out their duties. In terms of law enforcement, until now, the Polri has been in the public spotlight because the many cases that have not been completed, resulting in the emergence of public distrust of the police. The law enforcement function carried out by the National Police can be interpreted as part of the mechanism of the criminal justice system. Thus, the responsibility of National Police is very large as part of the criminal justice system. The National Police must be able to demonstrate to the public that all action in the framework of law enforcement must be perceived as upholding justice for the community. A decision taken by the National Police is considered fair by the community if the horizontal control mechanism is effective. In carrying out their duties as law enforcers, the police are required to use conscience in institution. Police must realize that society has changed as a result of reform. The use of next force must be directed and encouraged to be resolved in court. The ideal police is the police that can be legally protect perpetrators, victim, and society. Police investigators are currently experiencing various problems in law enforcement, which has become the focus of public attention. Many cases whose resolution is not clear, especially those related to the authority of the case, is not clear, but not completing the handling of cases. Result and areas of cases become the depth of the police investigator. The public will judge that the case handling is not completed or it disturbs community sense of justice. It will result in loss of trust to the police without finding out what the main cause is. The success and the investigator apart from being determined quite reliable is supported by adequate technical capabilities, facilities, and adequate investigate costs. In the examination of suspect and witnesses, appropriate tactic and techniques of examination are one of the absolute requirement of investigator. Coordination between the public prosecutor institution and investigator since the start of investigation state or case title, so that the different approaches between investigator and prosecutor have been elaborated since the beginning of the investigation. Or it can be said that relationship between investigator and public prosecutor is a communication space, not like a post box between investigator or public prosecutor. If this happens, back and forth examination of case file become unnecessary or very minimal, because investigator and public prosecutor already have aligned view and need for proof. So that in this carrying out an investigation, the two can complement each other. There is no need to wait until the end of investigation process, which is only limited in time to 14 days. Conceptually, either relation between public prosecutor and investigator can be carried out if their inter-subsystem are not limited by subsystem partition. There need to be a regulation in the Criminal Procedure Code regarding the limit for returning case file from the prosecutor's office to the police 3 or 4 times return of case file. After exceeding the limit, the prosecutor must take a stand regarding the case. Thank you.